Good afternoon, everyone. This is Greg Giardino with the Atlas team here at Wealth Enhancement. I'm joined here today with my fellow teammate, Steve Craffen, and we have a really exciting presentation for you today on estate planning. And I know what you may be thinking, this is not a fun topic to talk about what happens if I get an illness or I pass away, but it's really critically important to have a good foundation, a plan in place, or many things can go really wrong. So
And I want to mention that in this context of estate planning, we're not just talking about wills. We're also talking about things that actually could benefit you, if you don't pass away, which is having a power of attorney and also having a living will, which we'll talk about a little bit as well, and what can go wrong with those.
So on this slide, we're not going to bore you with our mugshots or our bios that we have. I think what's really important to know is that we are fee-only financial advisors. When we say fee-only, we are not compensated by third parties, so we do not get a commission if we recommend insurance or other investment products. So I think that's really important to know. And also, we specialize in working with the medical and physician community. Those are the folks we can most help.
And so, our focus is really on planning. We do manage money, we manage assets, and we charge a percent of what we manage. We're not paid by any third parties. We don't use investments that pay commission. I'm sorry, Greg, go ahead.
No, I was just going to say, really important for our listeners today that are hopping on now, that we are just giving you general advice. We're giving you advanced overview. We're not giving you specific advice. Of course, if you're looking for specific advice, please talk with the appropriate tax, legal, or financial advisor. And especially if we're talking about estate planning here, reach out to the appropriate estate planner as well.
And I just want to add a caveat to that. We do planning. We will help with estate planning. We are obviously not attorneys, so we can't draft documents, and we always want to be careful about unauthorized practice of law. We won't do that. But we do tax planning as well, by the way. Even though we don't prepare taxes, we do tax planning. And, I have a pretty deep background in the area of taxation as well. And we can also help you with that too.
And Steve, that's actually a great segue, because since we do some of that planning, make sure you stay until the end of our presentation, or you'll have the opportunity to sign up for our wealth.com planning module that we can do for you. So long story short is, if you have estate planning documents, you have a will, living will, durable power of attorney, hasn't been looked at in a while, you're not sure of some of the gaps that you have, we have this planning tool that we can use to do it complimentary for you. You can scan a QR code at the end, and we'll be happy to send it your way.
Yeah, I want to mention that this report is very extensive that we can do, and it'll look at your existing documents, and it'll give you a really good summary, and that's an important thing to have. For example, we're going to mention some of the parties to your that are going to be listed on your documents, including an executor. That's the person that administers your estate. And many times an executor, maybe a lay person that doesn't really understand the document, doesn't know how to read them, doesn't really. I'm not faulting them. It's just that a lot of times if you're not an attorney, it's hard to understand the documents. But this analysis that we can do for nothing will give you a very detailed analysis of the existing documents, and it may also point out some possible flaws in them as well. We're happy to provide that to you. And it's quite extensive. It could be a 30 or 40 page analysis. And also, if your documents are in great shape, it's something you can keep with them, and that way your executor will have a pretty good roadmap regarding what's in the documents and what they actually mean. So it's really very useful. So
you may be wondering, what are some of the things we're going to go over today? Just a high level, what are some of the pitfalls if you don't have some of these foundational estate planning documents in place, whether it be a will, a living will, durable power of attorney. We're going to go over all of that today. We're also going to review how different states have different rules. Looking at Florida, looking at New Jersey, looking at New York. What are some of the things you need to be aware of, especially from a tax perspective and estate planning perspective, and more. So I know we have here some core themes. Of course, having control is really important, because if you don't have some of these things in place, you may get the default plan. And the default plan may be based on your state, which you may not be happy with. So
we're going to mention that later on in the slides. I've seen it firsthand. I saw somebody die without a will, and we'll talk about that further. But it was not the best scenario for them, unfortunately. Yeah, and so you want to make sure you have the documents in place, especially medical professionals too, because and we're going to cover this too. But you may be in it still. You may be one of the physicians who still, or a medical professional still has their own business, and there are ramifications in that regard if you have your own business and you don't plan properly for something bad happening. And there's also liability exposure too, potentially, if you don't have your assets set up properly. Granted, I'm sure you have malpractice insurance, but there's also asset protection strategies, which we're not experts on that, by the way. And but we do recommend you potentially go to get legal advice on that aspect of this. We do know a lot about estate planning. In particular, in my case, I have a master's in estate planning from the Denver College. Again, I'm not an attorney, but I have focused on estate planning. And also, you may have rapid asset growth. Medical professional. Perhaps you really didn't you really get into your career fully until you're 35, 36 years old. But you could be very highly compensated, start to build assets up quickly. So you want to make sure that you have things in place properly. Even some simple things like if you have a IRA or a 403B, that you have the proper beneficiaries named, and also contingent beneficiaries, right, Greg, on that.
Absolutely.
Yeah. And you may be ignore some of this because of your time constraints, and you're not really compelled to do this. Obviously none of us really, it's not our first choice of something to do. But especially if you have a family too, you want to make sure you have everything in order too. So go ahead, Greg. You want to take this?
Sure. So there's really 3 foundational estate planning documents that we think every medical professional and physician, and frankly, most folks should have in place. So one is the will. So a will is simply, where does my stuff go if I'm not here? Yeah. So that will give direction. You can put different heirlooms. If you have cars, you have jewelry, things of that nature. That's really what a will dictate.
Physical and financial assets.
Absolutely. And then we also have a durable power of attorney. So that really has to deal with financial decisions. Now, you can also have a medical power of attorney, which will deal with medical decisions, and that's really a healthcare proxy as another name. Right. But if you're away in the Bahamas, who's going to pay for all my bills in New Jersey and pay my taxes? That's what a durable power of attorney would address, and arguably might be one of the more important documents you'd have set up to have a proper estate plan. Yeah. And lastly, we have the Advanced Healthcare Directive. This is really dealing with your health wishes, right? In the event something happens, who steps in, who has authority to make medical decisions on your behalf, whether it be surgeries, also for end of life, different situations. Usually, most attorneys will have a healthcare directive or healthcare proxy, and they may also combine it with what's called a living will. So the living will is really for those end of life decisions. Think of it as like DNR, do not resuscitate, that kind of thing. And right. Do you have artificial nutrition, etc. So really,
joke, Greg, that's why I interrupt. Remember, Tony Soprano was trying to get that on his mom.
Oh God.
In the Sopranos.
Don't know how that went.
Yeah. I just want to mention that the power of attorney is so important too. And by the way, there are 2 types of power of attorney. There's a durable and a springing. And the durable is more effective because the springing, unfortunately, doesn't come into effect unless they may mention that 2 people claim that you're not competent, or or you're mentally competent, or if you're in a coma, obviously it's clearer. But a durable is in effect immediately as soon as you sign it, and that's why you want to make sure that the person that has power over you, called the attorney in fact, is somebody you totally trust. Your spouse, and typically you want to have a second person in case your spouse cannot serve. But you want to make sure that you totally trust that person, because they're going to have very, very powerful control over your assets while you're incapacitated, or possibly something else is going on. So you got to be very, very careful with that one.
That's a great point.
Yeah, and there's you want to mention what can go wrong if you don't have the health care, right? Especially if you may want to even get that on, if you have children that are 18 and above, right?
I mean, that's another good planning perspective that you bring up here, Steve, because for our medical community that's listening to us now, if you
Right.
have now 18-year-olds going to college and they're far
Yep.
away, or they
Right.
have health issues, well, guess what? If they have a medical emergency, something happens, they're in the hospital, technically because of HIPAA law, they can't release that information in that hospital. So what we
Yeah.
usually advise our clients to do is, prior to your son, your daughter going to college or university, maybe have some planning documents in place. One being a HIPAA form
Yep.
to release the medical information. You want to have that formalized. And then second, we would also recommend that you have a medical power of attorney, healthcare proxy in place, so that if you need to step in for emergencies, you can do so.
And I want to mention also that that system we have that analyzes documents, we also have access to a component of it that will allow you to prepare your own legal documents. You don't need an attorney, and we're not involved in that process because we can. It's an unauthorized practice of law, but anyone can always prepare their own documents, and we have a system with almost pretty much no cost that'll enable you to prepare wills, a power of attorney, and this living will. And you can, if you have children, if you want them to do the living will, we're happy to turn it on for them. So that's another advantage that we can provide to you. And so you may have heard of the concept of trusts, and we've all heard about them. But there's two main classifications of trusts. There's revocable trusts. Those are also called grantor trusts, and there's some other types of trusts that fit within that category. And those are trusts that once you establish them, you actually still have control of the assets that are in the trust. So you can put assets in a revocable trust, you can pull them back out. And typically the taxation of the assets within the trust, any income generated, is generally taxable to the grantor, the person that establishes the trust. And an irrevocable trust is a trust where once you put assets in it, you have very limited control over it, if pretty much almost none in many cases. And there's purposes to an irrevocable trust as well. In both cases, there's a couple parties to the trust. You have yourself, and with the revocable, you're the grantor. Actually, with both, you may be the grantor. There's also the trustee. That's the person who manages the assets within the trust. You want to be very careful who you choose as trustee, by the way. And a lot of times people choose large banks or investment companies as trustee. I don't recommend that. I always recommend you keep the role of trustee and investment advisor separate. Even if you decided to choose, for example, our team as the investment advisor, something, if we do a bad job, you wanted the trustee to be able to fire us. And I've seen situations where somebody chose a large bank as trustee and the bank was not doing a good job, and they would have to go to court to get rid of the trustee, by the way. So it's a very difficult thing. So irrevocable trusts have their uses. We're going to go over each category a little bit more. I'm also going to mention that you may see sometimes people here in New Jersey say, well, gee, you should have a revocable trust for estate planning. Well, not necessarily, but in Florida, it's almost it is a necessity. We're going to go over why in a couple of minutes. But New Jersey, you don't necessarily have revocable trusts, and we'll go over it as I mentioned.
Steve, actually, if you don't mind, can we go back one slide?
Oh, yeah, sure.
Two things that just came to my mind.
Mm-hmm.
I think we want physicians and medical professionals to know, with a revocable trust, first off, creditor protection is not guaranteed with a revocable trust.
Right. Good point.
So it can be invaded, right? It's still in your name. Technically, when you set up a revocable trust, right, usually it's in your Social Security. It's not a separate entity and has a separate EIN number like an irrevocable trust would be. So I think that's one important point. And the second is the assets you put in a revocable trust. Generally speaking, you do not want to put IRA assets or 403B, 401k into a revocable trust. Yep. Why? Because it would be a deemed distribution. You'd have to liquidate, pay taxes to get the money in there. So keep that in mind. Once again, we're not recommending you do this, but very important planning points when you do eventually meet with an estate planning attorney.
Yes, or us, because while we won't draft the documents, we can help them explain some of the possible approaches. We're not going to give you a definitive answer. Of course, you need to go to an attorney, but we can certainly discuss some of the trade-offs with you. So, Greg, maybe take this one. I think we went over a little bit more here, some of this already, right? But maybe there's some points you might want to make here.
Yeah, I think another thing to know, I want our viewers to know, look, an irrevocable trust, right? You give up control typically. There's ways of modifying it, but for all intents and purposes, once you put the money in a irrevocable trust, it can't be undone, right? It's not
Yeah.
modifiable like the Rev Trust.
Nope.
Now, with that being said, just because you have money in an irrevocable trust doesn't mean it's always going to be creditor protected. It's not a panacea for
Right.
totally being sheltered from anyone, the government, or creditors. So there's a lot of things that have to happen when you have an irrevocable trust. And one thing I want to point out is the way it's drafted matters. So if
Yeah.
beneficiaries in an irrevocable trust, and you say, okay, well, my main goal is creditor protection, but inside the trust it has written, well, they have the right to withdraw at age 35, a third, at age 40, another third, and the last a third of the trust assets at 45. Well, guess what? It could be ruled that they could have ownership of the trust assets and a creditor could technically get access to it.
They can penetrate that wall.
So I want our viewers to know it's not a panacea. Just because you have the name irrevocable trust doesn't mean you're totally safeguarded. You really need to take some protective measures beyond that when you do some of this planning.
I just want to mention also, revocable trust does not necessarily file its own tax return because the taxation is going to the grantor of the trust. But an irrevocable trust does file its own tax return, and that does have there's ramifications there because trust tax rates they go to the highest bracket at a very low amount of income. I don't remember the exact number, maybe around 17,000 of income. They're in the 37% bracket. Now there are ways around that. You can distribute the income to the beneficiaries, and there's something called distributable net income that's on the trust tax return, and that's actually a deduction to the trust. So the income gets deducted, so it doesn't get taxed at the trust level. So these are considerations as well. And I've done trust tax returns over the years, and we are fairly knowledgeable in that area too. We don't do tax returns any longer, but we're fairly knowledgeable in that area. But we would work if you have a CPA, other advisor. We'd always work with that advisor anyway too, to make sure that you're doing the best thing from a tax standpoint. Okay. So here's some common trust types for an irrevocable trust, and we're not going to get into the details because there's a lot here. I just want to highlight a couple. The first is the first one, QTIP, qualified terminal interest property, and that's a type of trust that is generally created as a testamentary trust, and that term means it's created by your will, and it's a trust that enables you to control the assets, effectively control those assets when you're dead in terms of who they go to when your spouse dies, and it's a way to protect your children, quite honestly. And it depends on what type of family structure you have, whether it makes sense or not. And the other is an ILIT, which is an insurance trust, effectively. What happens in that type of trust is you typically establish a trust and you have an insurance policy which the trustee takes out on your life, and it's held within the trust. And it's really meant to do a couple things. It's supposed to perhaps provide liquidity. Maybe you have children from a prior marriage. You want to make sure that they receive an inheritance. So the life insurance policy is in their name, but you don't want that insurance policy to be affected by anyone else's will or let anyone else decide where it goes. Or also, perhaps you're in a state that still has estate tax. Now, on the federal level, the estate tax exemption amounts, I think, about close to $30 million for a married couple, right, Greg? Total?
That sounds about right. 15.
Yeah, it changes every year. It's adjusted for inflation. But there are some states, we're going to mention New York, has a much, much, much lower exemption amount. And so you may want to put some insurance in an ILIT to pay for the estate tax. So we'll talk about it further. And there's also marital trusts and special needs trusts. Special needs trusts are established for somebody, perhaps a child that can't manage their own assets and may have some sort of issue where they're going to be on government support for years, and you want to make sure they don't lose government support by having access to some of the income from those assets. That's a special needs trust. It is a lot here. We can certainly go over this more in detail with you if you want to talk to us, but it is a lot here. It's very complex. Greg, you want to maybe talk about this one? This is really a big one nowadays.
Sure. So digital assets, when we do a review, funny enough, if someone's hasn't updated their will or their estate planning documents in quite a while, 15, 20 years, it's not uncommon to see they don't label their digital assets,
Yeah.
whether it be passwords for Google, Facebook, their different various accounts.
Your
Some
bank
folks don't
accounts.
even folks don't even have a password manager, so
Right.
it can get pretty ugly here if somebody were to pass away and you don't give somebody legal authority to not only be able to log into your accounts, but also the passwords and where they're located. All of that information could really create a big issue here. So this
Yeah.
is one of those things you have to have a provision, a digital provision in your will. They also have digital power of attorneys. I don't see that as often, but you want to have some provision, some amendments in there that
Yeah.
speak to where these assets are and who can step in.
I want
Now,
to mention too, these days a lot of people use LastPass in their browser, and that particular piece of software will keep all of your passwords for your banking and everything else that you use online in LastPass. But the problem with that is you have one master password for LastPass, and your spouse or someone else, if they don't know that master password, they could be in trouble. So you may want to share that master password, even if you don't have it listed anywhere in any legal document. You want to share that with them. And that could actually cover a lot of it. It's not all of it, but a lot of it. And also, for example, if you have a code to get into your iPhone, for example, if they don't know that code, they could be locked out of that iPhone. There have been cases where even the FBI couldn't get into somebody's iPhone. They weren't allowed to, no matter how hard they tried. So you want to make sure that perhaps a very well trusted person, your spouse, or if you're not married, or someone else has access to these, or even if there's a common disaster, you and your spouse, that somehow you children can get into these records and get your passwords.
So to add to what Steve just said, for any of those listening that have iPhones,
Yeah.
after this presentation's done, please go on it, and there's a feature on there where you can name what's called a legacy contact.
Great point.
It basically says when you pass away, if for some reason your spouse, your significant other, doesn't know the PIN to open your iPhone, that they don't give it back to you when they pass away, and they wipe all the data clean, meaning all those family photos,
Oh,
precious videos. I mean, I
God.
got videos of my son on my phone. That would be devastating. So name a legacy
Yeah.
contact, not just your iPhone, but also on Facebook accounts and so forth.
Greg, that's a great point. I didn't realize that myself, Greg. That's a great point, by the way. Yeah. I probably have 35,000 photos on my iPhone. Yeah, look, it's replaced. I used to have I have a digital SLR, but I used to have a small camera for snapshots, and it's replaced it now. My iPhone, because you always have it available. Always a photographer say the best the best camera you have is the one you have available.
Yeah, no, the iPhones are great for that, and other
So
phones here.
let's talk about what happens if you die without having legal documents, in particular a will. Well, states have their own will for you, and you may not be happy with their choices regarding where things go. And we circled on this one, Florida. So we only picked out 3 states: Florida, New York, and New Jersey. But there's 50 states, and every state is pretty much specific. In fact, even your legal documents, you want them drafted by an attorney that understands the laws of that state. It should be state specific, of course. So Florida. So for example, if you die, and I circled at the top, a spouse and descendants from another relationship, 50% goes to your spouse and 50% goes to those descendants from another relationship. That may be kind of a nasty surprise. How about parents survive but no spouse or descendants? Well, your parents inherit the estate, and that's how Florida does it. By the way, if you die intestate, typically you got to go to court to get things done. Additionally, Florida's another issue in that regard. Also, we're going to talk about that in a minute. But also, if siblings survive, no spouse, descendants, or parents, your siblings inherit the estate. But that may not be what you really want to happen. And perhaps you may have a special needs child, for example, that you really should have set up a special needs trust for. Well, they may get assets outright, or you may have children that if something happens and they're not old enough yet to actually be able to control financial assets. You want to have proper provisions made for that as well, and you can do that in your will. And there's another reason too. If there's a common disaster and both spouses die, and you have young children, in your will you want to be able to choose who's going to act as guardian. for those children. You know, so otherwise they become wards of the court, and the court's going to appoint somebody, or interested family members can go to court and try to become guardian for them. But it's a legal process that could take a while, and the people who become guardian may not be your top choice. You want to be careful there.
And I may add, guardianship is super expensive. I mean, it's tens of thousands of dollars. What if they have to call in expert witnesses? It's a formal proceeding, right? You'll have to go to court multiple times.
Yeah.
I mean, it's not a cheap thing. I mean, it's tens of thousands. If it gets contested, it could easily rack up to $50K. So make sure you have a plan.
And I saw that firsthand too, actually, with a family member. And you know, my wife had to go to a court to become guardian of it. So I sat in on the court proceedings. I'm not an attorney, but I sat in and I saw it firsthand. So Greg, maybe bring this one up. This is New Jersey's kind of scary.
Yeah, so New Jersey, their default law is not great either. So if you pass away, you have your spouse and children from a prior relationship, right? You're in a blended marriage, let's say 25%, a minimum of $50K to a maximum of $200K, right? So right off the bat, your spouse will get 25%.
Yeah.
And let's say hypothetically you had $1 million. So 200,000 would go to your spouse, but then half of the remaining balance, right? So the remaining 800,000, half would go to the spouse, half would go to your children. So 400K each. Yep. So that could be a real eye opener for some that didn't put a plan together. That may not be what you want.
Yeah.
And even worse.
The next one is even worse, right, Greg? If you're married and don't have children.
You don't have any children, but your parents are around and you have your spouse. Well, guess what? Same scenario. You have $1 million, right? 200,000 off the bat goes right to your spouse. Then the remaining 75% of that 800,000 goes to the spouse, and the rest go to your parents.
Yeah.
So oftentimes when we interview clients, usually they may not want anything going to their parents, but this is something to be aware of. This is what happens in New Jersey if you die without a will.
Well, your spouse won't be very happy either.
No.
No. And I've seen that happen. So I have firsthand knowledge of it. You know, it's a shocker. You know. And then New York, Hayes, New York.
So we got the first 50,000.
Sort of similar.
Yep, goes to the spouse, then half of whatever's left, the remainder to children. So that may not be what you want. Once again, if you do not plan, you will get the state's default plan. This is what you'll have.
Actually, New York's a little better than New Jersey. New Jersey's a real eye opener. So, and here's like a little, you know, what happens, right? So, you know, a physician, you die, you know, a medical professional, die unexpectedly. You know, you assume everything's going to go to the spouse, but as you can see, that may not be the case. You know, so also you may have to go through the courts as well, and so the process will be slower. Things are not going to happen the way you want, and also the cost could also be higher for the people that end up getting your assets. So yeah,
I would say also what happens if somebody contests the will, right?
Right.
When you go to probate.
Yeah.
In New Jersey, I believe you have 9 months after death. You have to leave it open to creditors to make any claims.
That's great.
And then also, what if your beneficiaries are arguing and fighting? I mean, this can create a real contentious and stressful situation. And all it took was you to just put a plan in place.
Yep. I saw that firsthand as well. I've seen that. And yeah, it becomes a mess, you know. And in the meantime, you know, things aren't taken care of properly in terms of the assets, and you know, so they can decline in value if things aren't done properly. So there could be real hits. This is a good one, Greg, you want to take up?
Sure. So once again, hypothetically speaking, let's say you're a medical professional. You walk out of the hospital you're working at, and all of a sudden you get hit by a car, and now you're incapacitated, or conversely, let's just say you had a stroke and you can't speak now. You can't communicate. Yeah. Well, technically now you're incapacitated, and you know, who steps in for you? Who is able to make medical decisions on your behalf? Who is going to manage your investments? Who is going to, you know, sign off on signatures for you? You know, for bills, who's going to pay your taxes? So this can be a catastrophic event that can happen in itself, medically and but also financially, and just disrupt your whole homeostasis with your family. So
Yeah.
that was the best word I could come up with there, homeostasis. Anyway,
Well, they're
but
going to have to go through the guardianship process, which means you have to go to court and you have to, they have to, apply to the court to become your guardian and take care of your assets. Um, I mean, maybe a little simple if if you're married and you and your spouse have everything, tied as, a joint accounts and things of that nature. But that may not work out that well, too. So you want to make sure you choose the right person to take care of your assets and other things if you're incapacitated. So,
and then also this is going to, unfortunately for your family, cause unnecessary delays, right?
yes.
So once again, in a time of need, your spouse wants to step in, authorize things on your behalf. What if
Yep.
medical treatment is extremely urgent and necessary? Well,
Yep.
guess what? It's going to have to go through the court, the legal proceeding, and they're going to have to appoint a guardian. Now, they may end up naming your spouse, but you're going to have to go through a whole legal process. I'm sure they don't want to do that at that
Right.
time, right? This is catastrophic enough if you are incapacitated. I mean, this is really an awful situation.
There's another one, Greg. Suppose you're in the middle of a real estate transaction and something happens to you, and at the closing, if you don't have another person, your spouse, for example, doesn't have power of attorney, they may not be able to sign the documents at the closing for you on your behalf. So that's another one. So you want to have a power of attorney and a durable one, as I mentioned, not the springing. And by the way, there's always parties to these documents, and we mentioned that there's a trustee for the trust. They manage the trust, and they also will use their authority to dole out money to the beneficiaries. There's the attorney in fact, who is the person named on your power of attorney, and there's a person named on your healthcare power. But you want to really be careful who you choose, and you want to also, I think, talk to them. Obviously, if it's your spouse, it's easier. But if you're single or your spouse is not the person you've named, or perhaps you have a second, you should have a second anyway. You want to at least let them know that you've named them as executor or backup trustee or backup attorney in fact, just so they understand it. And they may say, well, gee, I really don't want that role. Or they may say, well, gee, you've given me that role. What does it mean? Can you explain it to me? And that's one of the reasons, one of the good things about this document analysis that we have that creates these summary documents. You could show that to them. You don't have to show them the whole thing, but you show them enough to have them understand it. Because there's certainly pieces you may not want to show them if they're not your spouse or somebody else. But you want to make sure that they understand what the role means. And there's also good books, that we can actually provide, how to be a trustee, how to be an executor, those types of things too. So anyway, let's talk about the estate tax. As we said, on the federal level, the estate tax exemption is pretty high now. If you're above probably 30 million, it's a concern. If you're below it, it's certainly not really a concern. New Jersey doesn't have an estate tax either, but New Jersey has an inheritance tax, and that's different. Estate tax means no matter who you leave your assets to, it's going to be taxed. An inheritance tax means, at least in New Jersey, if you leave your assets to lineal descendants, in other words, your children, which are considered, I think, Class B beneficiary, there's no inheritance tax. But if your assets go to a brother or a cousin, New Jersey's going to tax it, and we encountered that a couple times already. There's no estate tax in Florida, and New York does still have an estate tax. And by the way, it's rather onerous, by the way. And also probate in New Jersey is very easy. It's more administrative in nature. It's not really, it doesn't really involve the courts generally. Florida does involve the courts, so we're going to go over that real briefly here. In New York, it's not as big of an issue, probate either, but Florida it is.
And by the way, for those that haven't been paying attention to New Jersey tax law here, estate planning law, New Jersey used to have a New Jersey state estate tax.
Yes.
They've done away with that, I believe, in 2018. So
under Chris Christie, yep.
No longer have that, just so everybody knows.
Yep.
And another planning piece around that.
So Greg, maybe take this one. New York estate tax is really brutal.
Yeah. So aside from the federal estate tax, New York has a state estate tax.
And as we said, the federal kicks in around 30 million, but look at how low this one kicks in.
So if you're married filing jointly, the tax starts to really kick in after $7.5 million. So if you have a gross estate of 7.5 or more, you could see it gets pretty ugly pretty fast. It's
Yeah.
If we look at the middle column, that's the exact calculation of how much New York estate tax one would owe. And as you can see here, if you just mildly, if you're even $1 over, this thing kicks in on the whole amount of money that
And
you
all
have,
of it. Yeah.
all your gross estate. So this, you do not want to go over 7.5 million. As you could see here, even if you're a little bit over, it could be a 4% additional tax. Even if you're slightly over here, I think it's 299,000 and change.
Yeah.
Once you hit 7.7 million, that tax now jumps exponentially. Look at this. Now you're going to owe $734,000 on New York State estate tax, and all you did was go over by like $217,500 in value
nuts.
of your gross estate. So
Yeah.
this is a serious tax. We have clients here that are debating, should I retire in New York versus should I claim residency in PA? I just had a client ask me, and by the way, that's not always that easy. Just to claim residency and have 183 days, the states are now cracking down. We would recommend you work with a resident state auditor to make sure that you qualify now, because even if your own pet is in PA and you technically have 183 days in New York and you're trying to claim residency in PA, New York will come back and say, no. Your pet is here. Your life is here. You go to a golf course here that you frequent. This is where you have your golf membership. No, we're going to tax you at New York level. So this is something to pay attention to.
It really is. And it used to be like a 20-point test regarding residency. And I don't know how it applies in New York. And that's something for somebody who knows New York and what they've been doing. Sometimes it's not always just what's in the law, but it's what they've been practicing too. So it's tough. And so here's the difference in probate, which I'm not going to go over everything in this slide because there's a lot here. And we're happy to provide this information to you, the slides as well. But New Jersey is really easy, and I've helped clients actually go through probate in New Jersey. You don't really have to have an attorney in many cases, so you save a lot. And we can walk you through the probate process. We've done it. But Florida, typically people use revocable trusts, and they put their assets in a revocable trust because they want to try to avoid probate, because you have to go through the courts, believe it or not. And if you look at the fees under dual fees, that's on the column all the way on the far right, and you'll see the executor compensation. First of all, the executor gets compensated, and the attorney you have to hire, because you're really going to have to hire an attorney, because the probate rule requires a licensed Florida attorney for all formal estate administration. You're going to pay both. Both are going to extract their the pound of flesh out of the estate. And a probate timeline, it's not that much longer, but the problem is the courts get involved in it, whereas in New Jersey, normally they don't. So that's why they use revocable trusts. Many people in Florida, they try to avoid probate. And you can use a revocable trust in New Jersey as well, but the main reason you'd use it in New Jersey is more just to provide more privacy, but because typically probate's more of a public process. But if you're not concerned with that, there's really no reason to have it in New Jersey for the most part. It's one of the few areas where New Jersey is actually pretty easy. It's probate, It's surprising, right? New Jersey is becoming more and more bureaucratic and administrative and more difficult, but in this area, it's pretty good. So, and you see here on the living trust benefit, that's what a revocable trust is. It's a living trust. You see under Florida, very high. I haven't circled it, but it's all the way on the right and one row up from the bottom. So,
if I could add here, Steve.
Yeah.
My take on revocable trust here in New Jersey. Once again, meet with a qualified estate planning attorney here in New Jersey. But from my vantage point, if you're simply just trying to avoid probate, it may be unnecessarily. If you put assets in a revocable trust, that may be a little bit unnecessary.
Right.
And I think there is maybe two additional situations where I think a revocable trust could be a good idea. And I'll just explain real quickly. So
good.
The first would be,
I know what you're going to bring up, and I meant to do it, Greg. I know what you want, right?
You can read my mind here. One instance is if you were to get incapacitated and you don't want your family to have to go through the process of waiting to be able to get access of financial accounts. So usually when somebody passes away and they submit their durable power of attorney to the financial institution, I mean, it could take weeks potentially for it to get approved and processed. So if you have assets in a revocable living trust, they get access right away. There's no issue on, hey, is this going to get approved by the financial institution?
Right.
Bear in mind, nowadays, if you have any estate planning documents, not just the durable power of attorney, but if they are more than 10 years old, their policies now, for compliance reasons, they'll actually reject your durable power of attorney. So some institutions I've seen as low as 5 years old. So you really want to have these documents updated. If you don't want to have to deal with that, okay, there's a case maybe to put assets in a revocable living trust. Also, it's not uncommon if you have large brokerage accounts, if you have transfer on death accounts, large
TOD.
brokerage accounts. Typically, when somebody passes away, it's not uncommon for the financial institution to freeze half of those assets.
Right.
Now, if it's a spouse, you have to fill what's called the L8 form. Okay. So that basically releases the other 50%. That's not a terribly tough thing to get approved because it's self-affidavit, self-executing form.
Right.
Now, if you have Class C and D beneficiaries, if you're going to leave the in New Jersey to, let's say, your brother, your sister, well, guess what? They now have to get a tax waiver from New Jersey. And that tax waiver could take up to 90 days to get approved. So if you don't want to put your siblings through that, maybe you could put it in a revocable living trust. So once again, I'm not an estate planning attorney, but my knowledge of how some of these things work with the institutions, those could be two other considerations.
There's one other too I want to mention. If you own property in multiple states, so for example, you have a house in Florida, a house in New York, more than one state, you're going to have to go through probate in every state in which you own a piece of property, real estate. So you can avoid that if you have the properties owned by a revocable trust. You don't have to go through multiple probate then. And look, let's face it. I mean, you could be really egregious. You have to go through probate in New York and New Jersey, or potentially Florida. So that's another reason. You don't want to go through multiple probate. And even if you live in New Jersey, that may be a time when you definitely want to have a revocable trust if you own a property outside of New Jersey as well. Okay. Any others thoughts?
I think, well, no, I'll let you take this one, Steve.
Yeah. So we want to mention a complimentary estate planning review through a third-party app we have called wealth.com. And, we've already mentioned some of this, but it gives you a really good review, and it can help identify gaps and outdated provisions, et cetera, in your estate plan. And, as part of that, we'll also review and make sure you have the proper beneficiaries on your financial accounts, IRAs, 403B, that type of thing, and make sure you have contingent beneficiaries on them as well. And so we're happy to provide this to you. And you can do that. I'm not going to go through this disclosure. Obviously, we already mentioned we're not attorneys, and we can't practice law. We don't want it to try to. But you can scan this QR code, right, Greg? And you can enter your information in on the form that appears when you scan this QR code, and it'll go to us directly, and we'll contact you. And Greg, I think you were going to mention something else too, right?
I was just going to say, I mean, look, if it's been a while since you've reviewed your estate planning documents, typically we recommend every 5 to 7 years.
Yeah.
You really want to have them refreshed, redone. And quite frankly, if it's been a while, look, you want to make sure you have some of these important provisions. We talked about the digital assets. We touched on HIPAA, right? So if it's been 20, 25, 30 years, you may not have the up-to-date HIPAA language in there. Yeah. These are really important things you need to know. So we're happy to provide this service to you. Once again, just scan the QR code, take a picture now, type in your first name, your last name, and in the comment section, just put Atlas Team, and we'll give you a secure portal where we can review your estate planning documents, and we can provide that analysis to you. I think it's a great thing and a great way to get you moving in the right direction for those that have really put off their estate plans.
And I want to mention that we do write a monthly column in MD Life magazine, which you may get. And we typically, when we run these webinars, we typically accompany it with an article in MD Life that sort of is on a parallel path to the webinars we do. And we do these webinars each month, and we're going to be doing one, of course, next month. We haven't picked a date yet, but it'll probably be around the third week in August. second or third week in August. And I think we've already picked a topic, right, Greg? Private versus public investments. I think we're going to talk about that next time. Also, so if you want to contact us, you can also contact us through LinkedIn, and we'll message you right back pretty quickly. But we're happy to talk to you, and we look forward to it. Any other thoughts, Greg? Or?
No, just get to planning, right? Don't procrastinate on this. It's really important. Have something in place. Make sure it's up to date with some of the new law here in New Jersey, etc. And until next time, we'll see you soon.
Okay. And by the way, I just want to mention the recording will be available on our YouTube channel. It's yoursmartermoney.com, and also the YouTube channel for the Wealth Enhancement Group.
Yeah, so make sure you follow us and stay tuned for our next live webinar next month. Okay. All right. See everybody soon.